EIN after death, transferring or closing an LLC when a member dies. So in this video, we're going to be talking about a little bit of an uncomfortable topic that nobody really wants to talk about, but it involves one facet of estate planning and what to do with your LLC and what to do with your EIN number when the owner or the member of the LLC dies. So my name is Bobby Casey. I am the founder of businessanywhere.io. We do U.S. company formation and registered agent service in all 50 states. We handle your state compliance to keep your company legal. We help with opening bank accounts, bookkeeping, tax filings, pretty much everything when it comes to starting and maintaining legal compliance with your business. So in this video, we're going to be discussing the process and what to do when an LLC member or owner dies and what happens to the EIN number, what happens to the entity, in this case, what their heirs are meant to do. So first of all, you should be doing some planning before this happens. The best way to go about this is you should have a trust in place. A simple solution would be like a revocable living trust that determines who the trustee is, what the assets are in the trust, and who the beneficiaries are, because if that's set in place before the member dies, then the process for transferring ownership of that LLC, the paperwork is already done and it makes it a bit simpler. So that's the ideal scenario. You have a revocable living trust. You can make that revocable living trust the member instead of the owner being the member. Then it makes it super simple when they die to transfer the ownership to the new owner, maybe the spouse or the kids or whoever the beneficiaries are in this case. So in that scenario, if you did have a revocable living trust, when the owner dies, you would take the death certificate, you would take a copy of the operating agreement of the LLC, we'll discuss that in just a minute, you would take a copy of the revocable living trust, and then basically you would go to the bank and show them who the new owner is. You would sign a signature card showing them they're the new owner. You would need to do a membership interest assignment, assigning the membership interest from the old owner to the new owner. That would be handled by the trustee in this scenario with if you had the revocable living trust. Then the new owner or the member now becomes the member of the LLC, which is reflected in the operating agreement. And then lastly, you would need to file an 8822B with the IRS, informing them of a new responsible party for tax purposes so they know who the new responsible party is. So that would be one situation. What happens if you don't have the revocable living trust? So you've got, let's call him Tom Smith is the member. Tom dies. He's got a spouse or kids who would take over ownership and management of the business. Maybe they already operate in the business. So a good option would be there before Tom dies. If there's other family members or maybe beneficiaries or heirs, whatever, operating in the business, a good strategy before you die would be to make sure, at least at the bank level, they have signature authority over the bank account, so it makes it an easy transition. Then when he dies, basically you take the death certificate, and in many cases, the estate would have to go through probate, and the probate court would basically issue a letter saying this new person now owns the business. You take that court document and you take the company documents. Again, you would have to do a membership interest assignment, an updated or amended operating agreement showing or reflecting the new owner of the business. And then again, you would have to do that 8822B filing with the IRS telling them who the new responsible party is for tax purposes with the EIN. You need to basically transfer not exactly ownership, but responsibility for the EIN to the new owner. That would be really good situation, like a good situation if you had already added your heirs, spouse, kids, whoever as signature authorities, because when you go to the bank, they would already have signature authority on the company bank account, and it makes it easier to continue doing business. It's going to be difficult if they don't already have signature authority. You're going to have to move really quickly to make the transition, because otherwise you're going to be locked out of the business bank account. You're not going to be able to pay bills or do payroll or these types of things if no one else has signature authority over those bank accounts. And then with that said, if you're the owner of the business, you die suddenly and you did not give anyone signature authority over your bank account, it does create a bit of a problem. You will need to react really quickly You'll need to get that death certificate. You will need to, if there was no trust in place, you're going to have to push the court to give you a letter pretty quickly to go to the bank and add that new person on as a signatory on the bank account so that you can continue business operations. So I think the key thing to think about here is a little bit of pre-planning when it comes to these types of estate planning issues. Is ideally, like I said, you want to have some kind of trust in place, like a revocable living trust, or maybe you go an irrevocable trust, like an asset protection trust, that sort of thing. But that would help tremendously in the transition of the business to the new owners in the event of death. So I hope this was helpful for you. If you have any questions, you can reach out to us at businessanywhere.io. We do U.S. company formations, registered agent service, virtual mailbox, all of your company compliance, and basically everything you need to get your business started and maintain legal compliance. Have a great day.